My best wishes for 2026 to you and your family. I hope you have a wonderful year full of health, full of vitality, and full of growth. And as we talk about health, how about talking about healthcare and privacy? Privacy in healthcare has immense relevance, especially if you're a company based in the US. You have to comply with the GDPR because you may want to come to Europe at a certain time. You have to also comply with the HIPAA and many other legislation because in pharmaceutical and healthcare industries, what happens is you also have to do clinical trials, and that is a long process. And if you're following HIPAA, you also have to do expert determination. You also have to do risk assessments. You have to comply with, of course, all the laws. So it's not easy. Now, how about exploring how is privacy in the field of healthcare and how would it evolve in coming years? Let's do that with a special guest who is a chief product officer in a company that's serving healthcare data and privacy technology and who has also been in the healthcare and privacy space for a long, long time. And I'm talking about Timothy Nobles. So let's go and talk to him. And of course, remember to take advantage of growskills.store and learn about ISO standards and EU regulations.
Welcome to the Fit for Privacy podcast, where your host, Punit Bhatia, discusses the latest trends, challenges, and opportunities in privacy, artificial intelligence, sourcing, and related fields with industry leaders and experts. Whether you're a professional, business leader, or just passionate about topics like AI and privacy, this is your go-to place for insightful conversations and practical advice. The Fit for Privacy podcast is brought to you by FIT4PRIVACY, your trusted partner in AI privacy and sourcing matters, and Grow Skill Store, your go-to destination for top-tier training on ISO standards and key EU regulations. Remember that opinions expressed in this podcast are not legal advice. Now, it's time to dive into today's episode.
So here we are with Timothy. Timothy, welcome to the Fit for Privacy podcast.
Thank you. Glad to be here.
It's a pleasure to have you. And with someone who has such an expertise in pharma industry, I'm tempted to ask you or start with how do financial or not financial, I should say, pharmaceutical companies navigate the challenge of GDPR, the new laws that are coming up, and especially HIPAA in the US? I mean, what's happening? How do they see it? Do they see it as a problem? Do they see it as a solution? Do they see it as a business enabler? What do you observe?
I observed D, all of the above. So, that said, what we most commonly see is, hey, the regulatory landscape is changing, right? So technology all around us is changing, and then the use cases in which data can be valuable to these companies is also very rapidly evolving. And with that, the appetite to try new things is evolving, but then how do you do that against the backdrop of the regulatory frameworks? Where we see companies be the most successful is when they think about it, not necessarily in the explicit letter of the law. And to be clear, I'm not saying we don't pay attention to the letter of the law, but they kind of distill it to what are the core concepts. And the idea of mitigating the risk of re-identification is actually a central theme to pretty much any territory's regulation on consumer or patient privacy. And so now they word it differently, they sometimes describe it in different ways, but at the same time, at its core, that's what they're after. These companies are really taking this approach of like, okay, so how can I extract utility from the information without actually, raising the risk of re-identifying an individual? And if we do that, then we have the opportunity to produce strategic advantage because, especially as you start thinking about machine learning, data science capabilities, the almost dreaded buzzword of AI, in some extent, that gets a lot more, kind of complicated, but it also becomes a lot more unique because even if you're running the same type of models, you get two very different answers at the end based on what your business knows about the domain and then the types of information that you give it. And so starting in that position enables the companies to better navigate the various territorial regulations.
Yeah, I agree with you. And in this multi-law landscape, especially for companies that are conducting clinical trials, and clinical trials, as you would imagine, they have to be conducted across the board. You can't say we'll conduct it with European data or US data or African data.
Yeah.
It has to be globally done. So what kind of challenge do they face and how can that challenge be solved? Because it's practically very challenging to comply law by law.
Yeah, and clinical trials are an extremely complicated thing, whether it be site selection or how do you, attract qualified participants, and how do you sort of reduce waste and time? The most heartbreaking thing is the pursuit of a trial, and it takes 5 or 6 years to even build the panel for participants, right? And so with that, though, again, kind of a similar spirit to the previous answer is that when you're kind of focused on what are the kind of particular spirit of the law, where how might you approach the idea of, hey, are there other data points that I can pull from, sort of non-traditional considerations, and how might that be used to go create lookalikes and audience panels that aren't actually getting at one individual uniquely, but how could you use historic information out of consumer data and clinical data from, say, medical claims, and equivalents around the world to kind of understand the types of preceding conditions that often lead to the things that are of concern for a trial, where diagnoses have been made in the past, those types of things, and then how might you merge those, in a way that is compliant. And that's where there's a lot of very robust privacy enhancing technologies, tokenization capabilities, and then also very robust statistical models to help with some of the remediation, and then models to help with what are the lookalikes, what or where, how can you go attract, clinical participants. And what's kind of interesting in these types of approaches where we've seen them deployed so far is that the ability to kind of clear the territory regulation starts to increase, because at the core, you're kind of in a rolling start. And so then it's really more around, are there other considerations for how you manage consent, or how do you manage like the ability to be forgotten, those types of things. So they become a little bit more administrative versus the core data set. And then secondarily, it also allows you to kind of spin up the idea of running the recruitment in parallel to the site selection, versus what's often a bit of a kind of chicken and egg argument, that, well, if I don't have this, I can't go get people, but then it takes a whole long time to get people. So, then the clinical side's on hold. And, just produces a lot of frustration for all involved, because, the intention behind it is still, very good and very pure. But, it's like, how do you get rid of the regulation as being the core challenge? And so that's a bit of the way we've seen that work.
That makes sense. And if we continue the conversation between the GDPR and HIPAA, I think the US and the EU have taken different approaches towards the regulation. Is
Yes.
there anything, and of course, end of the day, the regulation is same as you mentioned earlier. It's about achieving certain objectives. But what is it that can be learned from both perspectives or both approaches?
Yeah, so GDPR, strictly my opinion, GDPR has done a really good job about us as individuals, right? So they were very thoughtful in the way they lay out the framework to give we as individuals a lot more rights and control over our data. And that kind of has a universal application. And here in domestic US, we saw the state of California, as it started to introduce its Consumer Protection Act, it actually had a lot of sort of kindred spirit, if you will, to GDPR in terms of introducing very similar types of rights, for us individually as consumers. HIPAA, on the other hand, kind of originated from a slightly different place. And, it's always kind of fun to remember that HIPAA actually started with the intention of preventing the idea of discrimination based on a health condition, right? And then it evolved very quickly from that, where it's also really important to be able to share information around, and then the idea of minimum necessary. So like how much information really is required to, handle the task at hand. And then how do you use this data in such a way that you're not betraying someone's identity, thus increasing the risk of discrimination. And so, their starting points are very different, but over time, they are kind of starting to come towards the middle a bit. Whether or not the US will ultimately adopt, that's a national standard similar to GDPR, that's up for our friends in Washington to figure out. But that said, it has been very interesting to watch how companies that act in the US, that are global, so they're headquartered somewhere in the EU, are just kind of coming in with a default position of saying, hey, we're going to balance these two things, and then how do we harmonize across the regulatory standards, and then here in the US in particular, how do we navigate what are state level regulations where they might have a different or slightly more strict interpretation.
And when you talked about HIPAA, and one thing that prompts me is there is something called expert determination concept in HIPAA. Now, not many people know it. So would you be kind enough to elaborate what is it and why does this expert determination under HIPAA offers an interesting approach for other global privacy laws or regimes?
Yeah, absolutely. So HIPAA is this huge bill all the way around. And within it, there's this security arm, and then there's this privacy rule. And the privacy rule basically outlines how you can work with data and pursue the idea of de-identified, which is the language the regulation uses, but it fundamentally means that you've successfully mitigated the risk of re-identification within the data set. The privacy rule affords two methods by name. One is called Safe Harbor. Safe Harbor has identified 18 unique identifying attributes within any data set. But the trick there is that it's very destructive. And so you just have to remove them wholesale. There's no nuance. They just have to go, they're gone. It's the cutting room floor, to use the editing analogy. Expert determination, however, is actually a statistical method. And so that brings on the idea that, hey, you can make various modifications and transformations to the data in such a way that you are provable through statistics have successfully mitigated the risk of re-identification to a testable and adequately low level. And not to get too mathy, but you're kind of talking about as close to zero as you can possibly get without it being pure zero.
Mm-hmm.
Which is really powerful. And so, examples, in this kind of end up being the idea of why you might want to, group and bin ages, right? So 5 or 10 year increments, and then anyone above the age of 89, you just generally top code them to 89 or plus. And then you can also think about a geographic area. Here in the US, we use this framework called a zip code, again, just for postal routing. And so there's a 9-digit version of it. Okay, that's pretty precise, and so if you have somebody that has an advanced oncology or a complicated, neurosurgery, something of that nature, the probability of there being more than one of those in a 9-digit zip code is pretty low. So with that, you can't keep that level of fidelity, but at the same time, you also don't have to get rid of the idea of a geographic definition. So how could a ZIP3 work, or how could a different geographic definition, here like a DMA or a CBSA be used?
Mm-hmm.
And then you'll see the same types of things in, codes. So like ICDs, in which case, okay, some of this gets so super precise, especially when you're dealing with oncology and ultra rare diseases, where, okay, is it okay to roll that up? Just take it up a digit or two kind of idea to enable the utility of the information to persist and be less destructive to the data set at large. The other thing that's really powerful that I think we're starting to see an increasing number of pharma and life science groups really latch onto about the expert determination method is that it can actually be living and breathing. And I'm sure you'll appreciate the point here. Very often, compliance and especially privacy is like, all right, you go through this exercise one time, you sit there for 12 or however many months, this particular configuration has been blessed. But the reality is that the landscape is moving so fast, the needs are moving so fast, technology is moving so fast, the data strategy has to be keeping pace. Mm-hmm. And if you have this very, very static and kind of cumbersome and almost stubborn sort of set of rules around privacy, businesses tend to get blocked by that. And the beauty of expert determination is that, again, I sort of sometimes playfully refer to it as like it's a bunch of really quick math to go do. Now, it's some very complicated math, to be clear, but if we can go run the math more quickly, how does that actually enable a company to better understand, even before they go make a data purchase decision or before they make a strategic commitment at the board level, even, how can they understand what this data set might look like post-compliance? And it's these types of things where the expert determination has, I think, kind of a bit of a universal opportunity to support kind of regardless of the territory in which you operate.
When you say you can use it regardless of the territory which you are in, do you, in your view, think that it's in alignment with GDPR's requirements?
Parts of. The GDPR, a very good question, by the way. The GDPR requirements are considerably more expansive. And again, where there are rights for the individual and where data originators, first party and third party participants, they have sets of rules. But the ability to say that the data has been, sufficiently anonymized and, de-identified to be in compliance with a very large portfolio of territorial regulations, the expert determination, like the math of that and like what it actually produces, seems to be very durable and seems to have a lot of application. Now, I'll be very clear to say it's not a one-for-one port. I have a number of lawyer friends that say, it's like 97 and then 3% left over, and so there's always a little bit of fine tuning relative to the specific regulatory framework, but in the spirit of like covering a lot of ground very quickly to help with perspective, and then you can work with the specialist in that area to do the fine tuning. That has shown to be a very durable path.
That makes sense. And we are in the age of AI, and expert determination used to be very tedious exercise, if I can call it like that, in the past.
Yes.
And is there a way, or is AI going to transform this expert determination process, in your view?
I think it already is, to be quite candid. We like AI in no uncertain terms. And that said, AI has a lot of dimensions to it, right? So the thing is that, we kind of very similar in the spirit of like, GDPR, I'll say there's a lot of consideration around what state does the data go, condition of the data is going into the models, these frontier models, and how are they being trained, right? And so with that, we actually see the expert determination technique, and method being highly valuable for model training, because you're mitigating the risk of identifiable elements wandering in. And the pattern matching and the predictive capabilities that are these large-scale language models, like they're so good at that kind of pattern matching, the ability for them to potentially rehydrate an identity is, that's a keep you up at night kind of scare, right? And so that said, this is where that method can be used to help allow data to be used in those training corpus, in a very ethical and respectful way, relative to the standards of the nations and territories. Now, the other part of it, though, is that now think about it. If you're, a pharma or a life sciences company, it's like, what's allowable, in my data, what's allowable in my configuration. And so this idea of, AI agents and the ability to kind of go query, I'm sure all of our friends listening have had the joy of reading more than one compliance report or an expert determination, and it's pretty dry and often a little confusing, right? But say you're a product manager, or say you're a team lead or an engineer who's just really trying to go in and understand, like, hey, can I use this data in this way? That's another place where we actually see a lot of potential at AI to help also describe and understand and help distill some of the more complicated aspects of compliance to make it more approachable and thus more adoptable by all of those that participate with data that does have this privacy regulation on it.
And especially when working with these clinical trials or international research, we hear this concept, just like expert determination, something called data clean rooms. What exactly is that?
I think if anybody can actually get a firm definition on a clean room, I want to buy them a coffee. That said, the spirit of a clean room is really this idea of, hey, go bring your high fidelity data into this environment, and then the only way any information can go out is because it's in a sufficiently aggregated level to mitigate this risk, right? And it also ends up being a much easier way to share. It's sort of like a neutral territory for companies to participate and share data. So you're also limiting data movement, which I'm sure we all appreciate that. If you don't need to move data around, don't. Just lessen your risk exposure. But with that, we've seen lots and lots and lots of adoption in clean room. We're also seeing a lot more of the spirit of take the code to the data versus the data to the code, across the industry, which I think is a very wonderful and very powerful move all the way around. And it also helps with de-risking in a pretty significant way. Because HIPAA in particular has this idea of minimum necessary, that specific language. Here in Nashville, Tennessee, where I'm based, that's sort of like our shorthand for like, okay, just because it's here, do we need it? And it's like, well, what's the minimum necessary? Like, we don't want anything we don't need to have. And so as a result, a clean room really kind of embraces that spirit. It allows you to take out only what you need, and it of what you're taking that's aggregated sufficiently such that, you can go support your use case, but you're also not taking on additional liabilities by having more fidelity than what you need.
So, while we talk about what is the situation in privacy and how people are approaching it, especially in healthcare, with the knowledge and breadth of experience you have, I'm tempted to ask you, how do you see the future evolving, especially from healthcare and privacy perspective in next few years, say 10 years or something? Because we will have this AI, we will have this quantum. Who knows when quantum will come, or some say it's already there. Depends on who you talk to. How do you see this evolving? What changes do you see in data privacy, especially in healthcare context?
Yeah, I that's a really fun question. I daydream about it routinely, So, that said, I sort of anticipate as the technology itself gets better and cryptography gets better and the ability to make secure at rest increasingly more robust, we will anticipate, especially in healthcare, we could potentially anticipate having more direct control over our records, right? So instead of, a health system uniquely sort of owning that information about us, we own it such that, as we need to, traverse or go through various different points of healthcare, the team at Harvard University had this really, great point of view on the idea of a diagnostic odyssey, right? And the fact that you end up seeing multiple specialists, on a multi-month, even maybe even a multi-year, journey just to get something diagnosed that's not overt and obvious, but how complicated it is to share the historic, what has been done, to inform the new specialist that you're seeing, on this journey. And so the patient in that case is having to rehash a lot of previous efforts in order to catch up the latest. And so, again, kind of as these cryptographic and at-rest methods get better, how might we actually take a more proactive role, and how might we, directly consent to allowing, being kind of more proactively involved in making those decisions on, hey, here you go, this is the history, and then subsequently, how could that potentially help the care teams that we're working with make better decisions more quickly. And with that too, of course, there's the inevitable, AI is doing very magical things, in terms of discovery, and when we can actually get the information more centralized and more purposed, where could kind of fit for purpose, models be more supportive. So I could see a lot of that happening, and then I think too, like the spirit of like the ability to edit what information is on file about ourselves at large. I really do have a huge aspiration that becomes more reliable, and it's like data brokerage and data originators, that's a very hard job for them. And, every one of those that we talk to, they all seem to share that like, hey, like we're into it, they're very committed to it, but the ability to get that to propagate and go far and wide and get, historic information deleted, based on our individual requests, that's not a trivial problem. So, where and how could, evolving processes, and then, I'll just loosely use the idea of like AI also contribute to helping with that, so that you're looking at, not only your current but historic data to ensure compliance with the current configuration.
So while you have shared so much about privacy, how it will evolve, and what's happening in pharma sector, tell us also something about you. How did you end up in privacy, and what are you doing in your day-to-day job?
Yeah, thank you. So I kind of always like to joke that I started life as a rock and roller. So I was a professional musician for 10 plus years. That was very gracious and took me around the world. And then a couple times over. And then, along the way, I kind of found myself in marketing roles, being based in Nashville, Tennessee. It's like very, very heavy healthcare. So it was an issue of, when, not if. And along the way in marketing, I was very data savvy. Really liked working with predictive models as early as that idea was true. And, kind of along the way, the more sophisticated the team and I were getting with the data, the more the question of just because we should, we do that. And which really kind of put me off down the journey of privacy. And so, the deeper, then I kind of made the conversion over to the product side of my profession, where we started building a lot more data products and analytics products that were being used by top health systems and top payers, and top pharma companies. And in that introduced many more complicated regulatory considerations. And so instead of fussing about it, I just leaned into it. And I'm like, okay, well, this is not a sweet process by any means, but like, let's go do this right. And I was always very, very grateful to have CEOs and boards that were like, we're doing what the law says we're gonna do, and that's get it right. And that was always a really great mandate to have. And so that allowed me to work with some really great counsel and determiners over the years to really get in and learn the particulars. It also led to a lot of good sparring matches of, hey, I still have to have this to hold on to the utility of the data. Otherwise, I don't have anything of commercial value. So how do we find the middle ground? That's really where I learned a lot about the depth of what can be done with an expert determination as a statistical model. And then out of that, then just the opportunity presented itself to come participate in making the process better, right? I mean, my experience in product was always that every time you realize you're going to need to get a new opinion letter or attestation or expert determination, you just kind of paused for a second because you knew like on a good day, it was going to be a 12-week process, in some cases 6, 9, 12 months, and those 9 and 12 months when just the business impact of that is dreadful, because very often, the strategic budgeting for the business had considered a product being available that compliance ultimately blocks. And I don't know a single compliance professional that wants to be business prevention. They all want to help the business move and grow. But at the same time, going through this very arduous process was, very difficult. And so the opportunity to participate with the company Integral that was really reconsidering how that could be done, and how could you do that literally in a matter of days, not an issue of weeks or months, was a very, very exciting proposition to me. So I packed my bags immediately and set forth. And so it's been really great to be able to support some of the biggest names, in pharma, and be able to help them find this path towards literally the idea of a living and breathing compliance relative to privacy regulated data, such that we have many companies that every month they're bringing on new data, and we're able to help support them with that just ongoing and constantly. And it's been really, selfishly, it's been really amazing to watch just the difference in the way in which teams are starting to work and think about data, because we're removing the barrier of the process of getting compliant. We're just turning that into something that's just natural. You just do it in real time along with the other work that you're doing.
Yeah, you're doing well. You're doing great. So thank you so much for continuing to do that. And now, based on this conversation, if somebody says, I want to get in touch with you, what would be the best possible way?
Yeah, so the website, useintegral.com, or LinkedIn. So it's just Timothy Nobles. And those are the two that get monitored the most.
Okay, that's good. So thank you so much. I didn't realize that time has just elapsed. And I'm so happy to have you. So thank you so much for your time and insights. It was great
Thank
to
you,
have you.
Punit. Yeah, thank you. I really enjoyed being here today. And thank you for the thoughtful conversation.
Thank you.
Thank you for joining us on the Fit for Privacy podcast. We hope you found today's conversation valuable and thought-provoking. Subscribe for more insights like this. If you enjoyed this episode, we'd appreciate that you'd share it and write us a review. For consulting, visit www.fit4privacy.com. For certifications and training on ISO standards, visit www.growskills.store. You can also contact us for bespoke training for your staff and management. Until next time, stay safe, stay compliant, and grow your skills.